Section 58 Mortgage, mortgagor, mortgagee, mortgage money and mortgage deed defined. Subsection A. A mortgage is the transfer of an interest in specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, an existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. The transferor is called a mortgagor, the transferee a mortgagee, the principal money and interest of which payment is secured for the time being are called the mortgage money, and the instrument, if any, by which the transfer is effected is called a mortgage deed. Subsection B. Simple mortgage where, without delivering possession of the mortgaged property, the mortgagor binds himself personally to pay the mortgage money, and agrees, expressly or impliedly, that, in the event of his failing to pay according to his contract, the mortgagee shall have a right to cause the mortgaged property to be sold and the proceeds of sale to be applied, so far as may be necessary, in payment of the mortgage money. The transaction is called a simple mortgage and the mortgagee a simple mortgagee. Subsection C. Mortgage by conditional sale, where the mortgagor ostensibly sells the mortgaged property, on condition that on default of payment of the mortgage money on a certain date the sale shall become absolute, or on condition that on such payment being made the sale shall become void, or on condition that on such payment being made the buyer shall transfer the property to the seller. The transaction is called a mortgage by conditional sale, and the mortgagee a mortgagee by conditional sale, provided that no such transaction shall be deemed to be a mortgage, unless the condition is embodied in the document which effects or purports to effect the sale. Subsection D. Usufructuary mortgage, where the mortgagor delivers possession or expressly or by implication binds himself to deliver possession of the mortgaged property to the mortgagee, and authorizes him to retain such possession until payment of the mortgage money, and to receive the rents and profits accruing from the property or any part of such rents and profits, and to appropriate the same in lieu of interest, or in payment of the mortgage money, or partly in lieu of interest or partly in payment of the mortgage money. The transaction is called an usufructuary mortgage and the mortgagee an usufructuary mortgagee. Subsection E. English mortgage, where the mortgagor binds himself to repay the mortgage money on a certain date, and transfers the mortgaged property absolutely to the mortgagee, but subject to a proviso that he will retransfer it to the mortgagor upon payment of the mortgage money as agreed. The transaction is called an English mortgage. Subsection F. Mortgage by deposit of title deeds, where a person in any of the following towns, namely, the towns of Calcutta, Madras, and Bombay, and in any other town which the state government concerned may, by notification in the official gazette, specify in this behalf, delivers to a creditor or his agent documents of title to immovable property, with intent to create a security thereon. The transaction is called a mortgage by deposit of title deeds. Subsection G. Anomalous mortgage, a mortgage which is not a simple mortgage, a mortgage by conditional sale, an usufructuary mortgage, an English mortgage or a mortgage by deposit of title deeds within the meaning of this section is called an anomalous mortgage. After reading this long section with definitions, let's understand this passage defines various types of mortgages in Indian law, along with the key parties and documents involved. Here's a breakdown. General definition. A mortgage is the transfer of an interest in immovable property to secure a debt or performance obligation. The transferor is called the mortgagor, the borrower. The transferee is called the mortgagee, the lender. The loan amount and interest are called the mortgage money. The document creating the mortgage is called the mortgage deed. Types of mortgages. Simple mortgage. The mortgagor remains in possession and promises to repay the debt. If they fail, the property can be sold to cover the debt. Mortgage by conditional sale. The mortgagor sells the property conditionally, with the sale becoming absolute upon non-payment or void upon payment. Usufructuary mortgage. The mortgagee takes possession of the property and receives its rents or profits to offset interest or repay the debt. English mortgage. The mortgagor transfers the property to the mortgagee but has the right to buy it back upon repayment. Mortgage by deposit of title deeds. In specific towns, delivering relevant documents creates a mortgage over the property. Anomalous mortgage. Any mortgage not falling under the previous categories. Additional points. The passage specifies certain conditions and provisions for each type of mortgage. It mentions limitations and rules for mortgage by deposit of title deeds based on location. The information applies to Indian law and may not be directly applicable in other jurisdictions. I hope this clarifies the excerpt. Feel free to ask further questions about specific aspects or related legal concepts. The Transfer of Property Act does not remain till mortgages. It proceed further if the any security of immovable property does not cover in mortgage, then it covers Section 100 and treat as charge on property. Section 100 charges, where immovable property of one person is by act of parties or operation of law made security for the payment of money to another, and the transaction does not amount to a mortgage, the latter person is said to have a charge on the property, and all the provisions hereinbefore contained which apply to a simple mortgage shall, so far as may be, apply to such charge. Nothing in this section applies to the charge of a trustee on the trust property for expenses properly incurred in the execution of his trust, and, save as otherwise expressly provided by any law for the time being in force, no charge shall be enforced against any property in the hands of a person to whom such property has been transferred for consideration and without notice of the charge. Section 100 of the Transfer of Property Act, 1882, in India, defines and regulates charges on immovable property. Here's a breakdown. Definition of a charge. A charge arises when immovable property, land in layman's terms, belonging to one person, A, is used as security for payment of money to another person, B. Importantly, this transaction must not amount to a mortgage. This means it shouldn't involve the transfer of any ownership interest in the property, which happens in a mortgage. Effect of a charge. B is said to have a charge on the property. This gives them a right to recover the outstanding payment from the property's sale proceeds if A doesn't fulfill their obligation. Most provisions applicable to simple mortgages also apply to charges so far as may be. This means that procedures for enforcing the charge, dealing with its priority over other claims, and other aspects similar to a simple mortgage can be followed. Exceptions. The section doesn't apply to specific types of charges. Trustee's charge. A charge created for expenses incurred by a trustee in managing trust property. Charge on transferred property without notice. If the property with the charge is transferred to a new owner who acquired it for valuable consideration, example, bought it, and without knowing about the charge cannot be enforced against them. Implications. Charges provide an alternative security mechanism for lenders without granting full ownership rights to the property. Understanding the exceptions, particularly the protection for bona fide purchasers, is crucial for both charge holders and potential buyers of the property. Additional notes. This section deals with immovable property under Indian law. Similar concepts may exist in other legal systems, but will have their own specific definitions and rules. For specific advice on legal matters related to charges or property transactions, it's always recommended to consult a qualified lawyer or other legal professional. I hope this clarifies the meaning and implications of Section 100 on charges. Feel free to ask if you have further questions or need more specific information.